A Texas high school teacher, already facing charges for an improper relationship with a student, is now under even more serious legal fire. 51-year-old Jennifer Massey, a former art teacher, was arrested after authorities discovered her allegedly engaging in sexual activity with a juvenile. Deputies were called to a construction site for reports of a suspicious person. What they found was a shocking scene. Massey was allegedly caught having sexual contact with a student. She was arrested and put behind bars, but now new charges are being filed, including sex trafficking. If convicted, Massey could spend years in prison. Thank you for joining us. I'm Kennedi Walker, and I'll walk you through the details. You're watching Law and Crime. Former Texas art teacher Jennifer Massey, first charged for an improper relationship between an educator and a student, is now facing a string of new, serious accusations. The 51-year-old was first arrested in October of 2024. According to deputies, Massey, a former teacher at Davenport High School in San Antonio, was found at a home under construction, where she was allegedly engaging in sexual conduct with a male minor. She was arrested at the scene and charged with improper relationship between an educator and student, a second-degree felony. So far, investigators have not disclosed the boy's age or the exact nature of the alleged conduct. Following her arrest, Massey was placed on administrative leave by Comal ISD and did not return to the classroom. In a letter sent to parents at the time, the school's principal acknowledged the charge, writing, "I know it can be quite disturbing to learn that one of our teachers was charged with a crime such as this. If your child has any concerns or questions, our counselors are available to meet with them as needed." The statement also noted that Massey was vetted and passed a background check before being hired. Now, nearly a year later, the charges are escalating. This week, prosecutors filing 4 new felony charges against Massey, including sex trafficking, sexual assault of a child, and 2 counts of indecency with a child involving sexual contact. Officials say the new charges are connected to the same 2024 incident. Massey was rearrested and held on a $125,000 bond. She has since posted bail and has been released. And here to break down the story with me is trial attorney Bridget Williams. Bridget, thank you so much for coming on today.
Thank you for having me.
So let's just jump right in and let's start with the new charges. How does something go from an improper relationship with a student to sex trafficking?
Those are 2 different offenses. So first, the improper relationship between a student and a teacher is a separate offense altogether, right? And that is because the teacher is held to a higher standard. They are held to a standard where they are in an authoritative position. And now pretty much I feel like they're taking advantage of that position and engaging in sexual conduct with a student. So that's why it's a separate offense. It's a second-degree felony. So that holds the weight of 2 to 20 years. Now, sex trafficking, that is if a person engages in trafficking of a person with the intent to force sexual labor or services upon that person. We don't have enough information just yet from what has been told to us to say, okay, well, this is sex trafficking. I don't see that just yet. But that is something that will more than likely come out as the case continues to evolve.
What's the legal threshold for something to be considered trafficking versus just an exploitation or misconduct? Because when you think about sex trafficking, I mean, you just automatically, think about, in the movies, sometimes of them, kidnapping kids and taking them across state lines. So in this case, obviously we're waiting on more information, but just if you could break that down for us.
Yeah, the difference there is force, right? That's the key word in sex trafficking or any type of trafficking is force. I traffic you with the intent to force you into some type of sexual labor or services. If we're talking about sexual assault, force isn't always required there, or sexual indecency, force isn't required. The key word in that sex trafficking charge is going to be forced into sexual labor or services.
I want to thank Odoo for sponsoring this news package. Odoo is a powerful, all-in-one business software that helps you manage everything from sales to accounting and, yes, manufacturing. Schedule your production, manage your assembly line, and fine-tune your work orders with Odoo's all-in-one, easy-to-use platform. Need fully assembled manufacturing software that will put your business ahead of schedule? Well, Odoo has you covered. Plus, Odoo's manufacturing app syncs seamlessly with your sales, inventory, and purchasing modules, so everything stays connected and running smoothly. Check out Odoo to take your manufacturing process to the next level and get a free 15-day trial today at odoo.com/lcnewsmanufacturing. The charges include sexual assault of a child and then indecency with the child. How do those differ?
That's a great question. So, sexual indecency with a child starts off with was their intent to gratify a sexual desire? So, that's the first requirement. And then, was there a contact, so sexual contact that was made? So, that can be sexual indecency. So, some type of contact with the desire, because of the desire to cause sexual gratification. Now, sexual assault, that goes a little deeper, and the requirements there involve penetration or the mouth touching genitalia, right? So it's one step further. And those things can be, if it's just sexual assault, that can be between adults, right? But sexual assault with a child or a minor, someone under the age of 17 years old, is going to be involved in some type of penetration, intentional penetration, along with if it involves the mouth and the genitalia of another.
These new charges are coming months after her original arrest. Is that a sign that prosecutors were quietly building a broader case?
It could be, however, it could also be that there was just more information that was involved and it came to light. Statute of limitations on cases like that can go up to 20 years. A sexual assault case of a minor, there is no statute of limitations here in Texas. So they can bring a case 20 years from now if they chose to. Bringing a case months later is not uncommon. That happens quite frequently, actually.
Right. Well, because I know, some may be wondering if the new charges stem from the same incident, why weren't they filed from the start? Could that raise issues for the defense?
I don't know if it could necessarily raise issues. I don't think that that raises issues at all because the elements are different for each particular offense. So just because they weren't charged with the day of doesn't mean that there isn't grounds for additional charges. So even if it comes from the same course of events, the elements for each offense are different. And so they may have believed on the day of the officers who made their arrest, they know that they have enough evidence for the offense that they did charge her with. But then as they continue to do more and more and they take a look and have an investigator look into it, more and more things, then they're like, okay, this meets the elements for all these other offenses. Okay, now we're charging her with these other offenses.
Right. Well, yeah, you bring up a good point there because we know that sometimes prosecutors stack charges. And so you're saying in this case, you don't believe that that's happening here. But when that does, how do judges view that kind of strategy?
Well, we're not even at the point yet for it to be at a prosecutor or stacking charges. When we bring a charge against a person, it's the police officers making the charge. They believe that they have no probable cause for an arrest, and then because it's felony cases, it has to go before a grand jury, and then the grand jury has to make the decision on if there was no probable cause for arrest. Then it goes to a prosecutor. So there's a process. I would say it hasn't gotten to that point yet where a prosecutor believes that they're stacking charges. But if it is, they definitely can do that in this particular case. And then so when we say stacking, it's just saying that you meet the elements for each of these offenses and you can be charged with each and every one of them. And so that doesn't necessarily mean that they have a stronger case for one or the other. It just means that the elements for all of those have been met.
Could these new charges suggest there's more than one alleged encounter, even if officials haven't said that yet? Because I'm just wondering for sex trafficking, does that count if hypothetically, they lived in one county, but they were found in another county?
So the two charges for sexual indecency, she has two separate counts of sexual indecency with the child. That very well indicates that there were two separate encounters, right? So the first encounter may have happened on one day, the next encounter may have happened a week later. So that could be one thing. The sex trafficking, I'm not really sure too much about that because what I would say is that when we talk about sex trafficking, again, was the trafficking with the intent to force this person into labor or services? And so that doesn't necessarily mean that they had to cross into another county. That would raise levels of, should the case be even brought in this particular county. So the case is brought in the county in which the offense occurred. So the trafficking just doesn't mean it went to another county. That just could be, again, because there was forced labor or forced services that were performed, or that were intended to be performed.
Well, what happens next? I know you mentioned we're still kind of early in the process. Could this go to trial soon, or will it likely drag on?
Cases like this don't always go to trial very soon. It could be a year from now before there's an actual trial setting. Whenever there's an arrest that is made, then the person has to post a bond if they can get a bond, if a court decides that they can get a bond. And if so, they'll post that bond, and then they'll be out until there is a court setting, and that could be a pretrial setting or actual trial setting. So until the case is resolved. So the next steps would be for her to get a bond, post that bond, be removed from jail until the case moves forward. And then the next steps on the DA's side is presenting that case to a grand jury. If the grand jury decides that there was enough probable cause, then it moves forward to an actual court setting, which is pre-litigation, and see if they can come up with some type of agreement, if there's an offer that's made or something like that. And if there's not, then they move forward to a trial.
Well, what kind of defense could her attorneys even bring or make in a case like this?
Yeah, that's a tough one. Whenever we talk about what a defense is, we have to go back to the Texas Penal Code and what are the affirmative defenses. And so the affirmative defenses, let's say in the sexual indecency, was this done with the intent to satisfy or gratify a sexual desire? It's tough, right? Because clearly this is something that could have very well been seen in that light. And so it's going to be a tough call. I think that it's going to boil down to the details in this particular case to see what the defenses could be. And those details come out in discovery and in the evidence that the state provides to defense counsel. So all of those little details is what matters for the defenses.
But from a legal standpoint, in your opinion, like if you were trying this case, what does her team need to be doing right now to stay ahead of these new developments?
Things that they would need to do would just be making sure that she doesn't get into any other trouble, making sure that she doesn't have any contact with any children. More than likely, her bond conditions will say that she cannot have any contact with any of the victims or alleged victims. We have to say that word, alleged victims, in this case, and she cannot have any contact with any minors until this case is resolved. So making sure that she fulfills the terms of the bond, doesn't get into any other trouble, cannot pick up any new cases. I would be telling her, stay at home, and not do anything that could put you in jeopardy or be seen in a negative light. This is in a small county that this is happening in, where everybody probably knows each other and everyone knows and watches the news and things like that. And so I would be telling her to just pretty much try to lay low as much as possible so that way she's not seen in a light that could be harmful to her case going forward, or more harmful to her case.
Well, you bring up a good point there, just with the small town and if this does go to trial and they have to pick a jury, how do, just attorneys make sure that the jury isn't biased, right? Because I'm sure there's going to be parents on the jury. I'm sure, how do they make sure that their client truly gets a fair trial?
Yeah, and that's always such a gamble, right? Because there's no way to guarantee that. The perfect answer would be to change venue, but there would be no way to guarantee that a judge would grant a motion to change venue, which is just changing counties, to say that the person could get a fair trial in another county. But so let's say that the court grants that, then wonderful, we move to another county. The court more than likely will not grant that. So in a situation like this, then the defense counsels, and prosecutors both will be asking questions to try to identify bias in the what we call voir dire, and that is just where we question the jury members ahead of time and see what biases they have. So, like you said, if they're a parent, if they believe that they cannot set aside their own feelings about parents and what that feels like, or if they've ever had something similar happen to someone that they know, or even in their own situation, do they have biases against police officers? whatever it is that they have, they're trying to get that out of people in probably like an hour time frame. So it's a lot of work in the voir dire process. And so I would say that they're going to be preparing very intensely for the voir dire and asking as many questions as possible. But even then, you don't guarantee that people don't get on your jury that have biases. So it's a gamble.
Right. And in your experience, I mean, just how do judges and juries usually react when a teacher is the defendant in a case like this?
You're going to have initial shock, right? I think in any criminal case, sometimes you're as a defense attorney, you're already starting off, I would say, on the end of where people believe that the person is guilty, right? You start off with that indication, because a lot of times people think, well, why else would they be sitting at the defense table if they're not guilty? And so, as a defense attorney, you have to have the conversation with those jurors to say, well, just because he's sitting here doesn't mean he's guilty. That just means he's been charged. The level of what he had to meet to be here was probable cause. The standard for a trial is so much higher. It's beyond a reasonable doubt. Meaning that, do you have any doubts in your mind that he met all of the elements of this particular offense and was it reasonable, right? So the Texas Penal Code doesn't tell us any other type of explanation for that. It just tells us, again, do you have a doubt? And if it was reasonable, then you can say, well, I believe that should be guilty. But you're fighting that uphill battle just from the start.
And that uphill battle, is that usually just because the public reaction is already emotional?
Yes, I would say emotional, but also just some people having their own biases. So, like I said, if someone is charged with an offense, a lot of times people believe that just because you were charged and because you're sitting here, that now means that you're guilty. And that doesn't necessarily mean that. In this particular case, we don't know because we don't know all the facts just yet. But a lot of times in my experience, we have had to kind of overcome that during a jury trial just to explain to people, just because we're here doesn't mean that he's guilty already. We have to give a fair shot to this person, listen to all the evidence, put aside our biases. So whatever you thought that you came into this courtroom and whatever thoughts that you had, feelings that you have to say, I agree. I will put aside those biases and be fair and reasonable to this person, listening to both sides fairly.
Right. And so in this case, we don't know exactly how old the minor is, but I know that in cases like this, and they do release the age, and let's say the student was 17 years old, some people are like, well, how is that a crime, right? If the 17 is the legal age of consent, how can a person be found guilty? But Massey was in a position of power. So can you just explain, does the law automatically treat teacher student cases as predatory, or is there a nuance?
There is a law that says that the teacher and the student's relationship is completely different. And that's why it's a completely different offense altogether. And so it's a second degree felony because the teacher is in this authoritative position. They are in a position of power, right? You send your child to school, you think that they're in a safe environment. And now you have a teacher who is now taking advantage of that position in order to now engage in sexual activity with a student. So they are taking advantage of their position of power. And that is the reason why it is a separate offense from just a regular sexual assault charge. You can be charged with a sexual assault charge and now with this violation of the student teacher type of relationship.
Could this case lead to tougher laws or new rules for vetting teachers before they're hired? Because I feel like this happens more often than not. We're hearing about these teacher student alleged relationships.
It should require there to be more vetting for teachers, and we know that they go through background checks. We know that they do just a analysis, I guess you could say, on all of the teachers that are there already. But there could very well be more vetting for teachers based on things like this, or not just vetting, but then making sure that the teachers are doing their due diligence with students throughout the process once they're hired. So even after they're hired, just kind of taking a closer look at what's going on in schools and what's going on a day-to-day basis.
Is there any legal exposure or liability for the school district here, especially now that sex trafficking is on the table?
That's a great question. A lot of times, school districts in Texas have immunity. And so, whenever there is something that is done, let's say like a charge that happens on the school's campus and things of that nature, Texas has immunity for government places. So, anything that may be a government school, a government building, a government location, anything like that generally has immunity from suit. There are very, very small, minor exceptions to that rule, but the general rule is that they have immunity from suit.
If convicted, what kind of sentence is Massey realistically facing with these new charges?
That is something that could just be up to a jury, up to a judge. It depends on the details of what comes out in discovery. That's always what it boils down to. What is in that discovery packet? And then what does a jury or a judge hold that weight to be? The range of punishment is 2 to 20 years on most of those cases, on each individual one. More than likely, a judge runs those charges concurrently. So if a person is charged with, let's say, 3 charges, they're normally not stacked. So it's not like 20, 20, 20, 60 years. It's more than likely, let's say, 20 years total, and run the charges concurrently. So that's more than likely what would happen.
Are there any mandatory minimums in Texas for child assault or sex trafficking?
So mandatory if she has a let's say a prison sentence, then 2 years is the minimum. If she has a probation recommendation, then there might not necessarily be a 2 year minimum. So it just, again, it depends on what comes out in discovery and what happens in the trial.
And in many cases like this, I know, and it could be whether civil or criminal, we see plea deals. Is that something that we should possibly expect in this case as well?
110%. A lot of times the prosecution, they're going to offer something, right? They generally offer something. It's rare occasions when the prosecution doesn't offer anything, but they will offer something. If it is a preposterous plea deal, right, then the defense counsel will decide to move forward with a trial setting, or based off communication with the client. If the client says, "Hey, I'm not taking anything at all," then it's going to move forward to a trial setting. And so, but more than likely, they do offer something. It's just a matter of, does she want to accept it, and is there something that can mitigate whatever that offer is from the prosecution that the defense counsel can negotiate with.
Well, this is a case that we will be following closely. Bridget, thank you so much for coming on today.
Thank you so much for having me.
The investigation remains ongoing. For Law and Crime, I'm Kennedi Walker.